everyone. It's lovely to be here and hear you on this forum today. Uh, we've got Ian with some terrific topics to cover, and we've got a guest speaker also. Um, Terrific to come along. Let us know, let us have your feedback for this, as we're always at pains to say it's your forum. Tell us what you'd like us to talk about or who you would like to be on it, and we'd be delighted to try and get something done. I'll just hand you over to Ian, who can take you up on this.
Thank you, Liz. Thank you. So good morning, everyone. Good afternoon, everyone. Thanks for joining us. I hope anyone that was watching the golf yesterday has enjoyed it as much as I did. The purpose of today, as with all forums, is just to invite anyone attending to raise any issues, problems or topics that you'd like to explore. In addition to that, we can look at topics for future events and look at speakers for future events. I'm delighted to say that in addition to the Stewart title presence, which we have Liz, John and Robert in attendance today, I've also got a dear friend of mine, Mr. Richard Pickles from In Touch. Good afternoon to you, Richard. Thank you very much for coming along. I'm going to have a word with you in a minute or two, Richard, but before I do, Stewart titles, contact details and product information on slide here. Liz, John and Robert are able to provide guidance and assistance with regard to title indemnity insurance for Northern Irish practitioners. John and Liz sort of featuring heavily with regard to business development and support in Northern Ireland. Robert being based in London, but again, able to provide advice and assistance with regard to policies generally. Stewart Title has an online presence and has the ability to issue policies online, and there's details there. And I think, as I recall, Robert, it's necessary simply for someone to register, and that is just simply a question of filling a form in and then being able to go online and put forward proposals and issue policies. Is that right, Robert?
Yeah, that's right, Ian. All the policies that we provide in Northern Ireland are available on there. And one thing really about talking to members of the industry on events like today is to see what else you'd like to have on there, what else we could be doing to provide solutions for you. So always very happy for some feedback.
Fantastic. Thanks for that, Robert. And contact details on the slide there, Liz and Robert, and general information available on the various websites and email addresses. So a massive thank you to Stewart Title. John, Liz and Robert and the team at Stewart Title are always, as Robert mentions, willing to look at products and willing to look at innovation, also willing to provide training and assistance with regard to product knowledge and product awareness. I've been fortunate enough to work with Stewart Title for a number of years, and there's a number of things that are really interesting. One, recent expansion with regard to new underwriters. Two, a willingness to reach out to firms throughout the United Kingdom to provide assistance and guidance to practitioners and to provide training in connection with compliance. So contact details there. If you're an existing client of Stewart Title, fantastic. Do be aware that they're frequently innovating and developing, and as I say, I know they've got a whole host of new members of staff to enable additional work to be taken on, and in addition to that, happy to speak to people either virtually or face to face to discuss the requirements of your firm. Massive thank you to Stewart Title then for sponsoring this and for sponsoring conferences and all our CPD training that we offer. As I mentioned a little earlier, Mr. Richard Pickles is with us today from In Touch. Richard, Robert and I frequently attend conferences, etc. So I feel, Richard, as if we're with each other every week. But thank you so much for giving up your time today to share with the delegates and attendees today about the work that you're doing as far as In Touch is concerned. And I think the interesting thing, Richard, from my perspective, is the fact that you do a lot of work in Scotland, a lot of work in Northern Ireland. So it's not just a question of your being an English-based and English-facing sort of company. And I think the other thing that I think is important, just as Stewart Title are, you're not sort of providing services to the legal profession, but really you're part of the team. So clearly, Richard, you're in a better position to explain a little bit about what In Touch does. If you don't mind, I'll endeavour to do my best to manage the slides for you. All you have to do is shout louder if I get it wrong, but I'm happy to take charge and to push the slides along as and when you require it. So over to you, Richard.
Thank you very much, Ian, and thank you very much for doing my presentation for me as well. That's very good of you, and will save me drinking a load of water. But if you can move on to this is me, by the way, sales director of In Touch. I won't overly talk about In Touch, and I won't sell it to you really hard, because I don't believe in doing that. We're very cooperative, and we work with you, and the whole idea with In Touch is that it works with you, and it's yours, and it works for you. If you've got a case management system that you feel isn't working for you, and isn't yours, you're not in control of it, then you definitely probably need to be looking at a more modern solution. We're not limited by legal jurisdiction. We have clients in Scotland, we have clients in Australia, all over the United Kingdom and Ireland. We even have clients, or one client each, in Kenya and South Africa as well. So not limited at all by legal jurisdiction. In Touch, like any modern case management or matter management system should be, is completely flexible and configurable all the time. Let me just see. Move 8 are the Scotland one that are identified on here, and First Class Legal are the ones in Australia. Don't know exactly why we've got that spot there in Ireland. We certainly have, as I'm thinking off the top of my head now, more than a couple of clients in Northern Ireland itself. So we are covered everywhere, even if you've not heard of us much before. Okay, Ian, next slide, please. And I'll try not to bash on for too long, by the way, as well. So your case management should solve problems for you. It should take the hassle out of your daily living, and it should make your lives easier. So it's really important that we sort of like save people time on the phone, and that's generally because we have a client portal that you can not just put your buyers and your sellers on, you can put any of the stakeholders on, and stop those phone calls. And overall, just through making things easier and making sure everyone follows the same process on each matter, we save between 2 and 3 hours per matter. Some of the areas of law where we work are, simpler workflows than there are in conveyancing. As you know, conveyancing is one of the more complex ones with more third-party involvement, that kind of stuff. So conveyancing saves generally on the top end of that. So the 3 hours is where you should be looking, and certainly significant drops of calls and email volumes as well. This is not just In Touch. This is where you should be aiming if you're looking at changing your case management, your matter management. Okay, Ian? The way we do that is because we just work across the whole matter life cycle. So we're there. It's almost like a universe now. So we're there from attracting new clients with quote generation, and managing the leads that you get in. So even from putting in little quote generators on your websites that mean, if someone has made an offer on a property on a Saturday after seeing it, and then decide to look for sort of quotes for conveyancing over Sunday after their Sunday dinner, you can actually provide them with quotes or capture the lead. And then obviously get them onboarded. We've got digital forms. We've developed our own e-signature solution, so you're not having to buy that, and it's all included in the price, and you can have as many as you like of them. And we often encourage our clients, it's just one of those little tips that we found works, that if you get a signature from them as early as you can in the process, even if it's, I just accept this quote, you're actually getting commitment from your clients, and it just stops them falling away, and stops them dropping out. Obviously, we build the workflows. Another thing to bear in mind is that every workflow should be the way that you do it. We have standard workflows that we issue with people, but we often find that people start tinkering with them almost immediately and start making them work for themselves. And we go with you through the onboarding process to make sure that it's your workflow, not ours. and it's you'll be surprised at how easy it is. I'm not a techie, but I have built in the past month. I've built a LPA one with one of our clients. I've built a wills matter, and I've done an estates as well matter, all with our clients and just working with it. You don't need to be a techie to do that. Okay, Ian, next one. Oh, we also make use of AI as well. So we've got AI. Strangely enough, we're doing an AI webinar tomorrow. And what we're doing with AI is we're using AI to, again, take out the boring aspects of people's work. And we're not just issuing it and saying, there's AI, make use of it. We're actually sort of drip feeding it into the process so people get used to AI and what a powerful tool it can be. So we're trying to do that and make it easier to understand for everybody. Okay, thanks, Ian. Automated emails, secure messaging, stakeholder management, that all comes through the system. So you can set up tasks within your workflow to send automated emails. You can set up tasks to send secure messages. And we have a portal as well. As I said, it's not just for the buyer and the seller. You can have the estate agent in there. You can have the mortgage brokers in there. You can even have the gifters if there's a gifted deposit and that kind of stuff. Searches, we have some really good integrations for your due diligence searches. I'm thinking, let me think, InfoTrack, TM Group, Third Fort, Pally, and PLS. So off the top of my head, those are some well-known integrations that we'll have. We have something like 13,000 search orders go through the system per month. So even if you've never heard of InTouch, we are of quite a decent size now, and 6,500 users, I think, on average every month as well. So the relationships as well, the final box here, manage those through the client portals. You can allow people to see where the sale is and follow the sale progression. And obviously, like anything that you should even consider at the moment, it has an audit history. And I know Stewart Title will talk to you at length about if you want to reduce your premiums, if you've got audit history on everything that you do, and if you're following the same process every time, that will have a big impact in your premiums. Next, please, Ian. So yes, because we work in, I know conveyancing is very much set fee stuff. But we do work across all areas of work. So time capturing can be important as well. We follow through on the far end as well. So into post completion, into making sure the client accounting is done correctly. Completion statements are done. We integrate with Xero and have a really, really good full finance system as well. And then nothing's no good unless you can report on it and measure. So we have a really good and very flexible reporting facility as well that looks not just at real-time reports, but performance analysis, so you can compare one of your teams with another, and capturing client feedback as well, which is always good for your websites. And everything else. Okay, Ian, next, I think we're coming. Oh, here's some integrations. Yeah. So you can see a load of them there. So searches, AML checks, IDs, billing through Xero, but some well-known names there that everyone will know. Next one, Ian. Okay, why do law firms choose us? It's 100% cloud-based. If people don't know what that is, it's just like jumping onto the internet. So you can access us anywhere you've got an internet connection. It means that it's wonderfully scalable. You've no service to run and maintain in your own office, that kind of stuff. You can get a bit of space back if you're still running servers. And you get automatic updates there in real time. So it's continuous. Whenever you log on, you've got the most up-to-date system that we've got. Our responsibility is the redundancy and failover, and we take that obviously very, very seriously, and have the strongest security measures. And again, everybody should have that now, strongest security measures, and the highest standards that you possibly can. Multi-platform friendly, you can use it on Macs. We did have somebody who asked us that. I thought the whole world in business operated on Windows unless you were in advertising or something creative, but apparently some people do law on Macs as well. So loads of reasons why you should look to firms that are cloud-based. It just makes more sense nowadays as well. Thanks, Ian. Yeah, full onboarding. We map your processes, we build your processes, we build your workflows, we onboard your teams, and then we continuously support you as well. And it's people. It's not a email is here and you'll get a number, and then you go on. And we're very proud of this, and we measure it all the time. Over 90% of queries that come into InTouch are solved on first call, and long may we reign on doing that, because that's the important thing. Thanks, Ian. Just about got in with my 15 minutes, I think.
You did. Richard, a few things. First of all, you were saying about, I won't give you the hard sell. One of the reasons I love working with you and InTouch, I know you don't. Same with Stewart Title. The product sells itself. Richard, one or two things. Firstly, if someone wants to take things further, they contact you, and it is a sort of virtual meeting to show people. How does it work?
What we do, I mean, InTouch, as I said, it covers everything. So it's a whole universe. Yeah, get in touch with me. I'll just do a real quick 10-minute discovery call with you to find out what your problems are. If we found that if we try to demonstrate everything, it's 2 hours. Yeah. And I know my attention veers off into all over the place after about 20 minutes, to be fair, but but 2 hours is really stretching it. So what we like to do is find out what your real pinch points are. And although we'll show you the whole system, we'll drill down into where your current problems are and showing you how InTouch will resolve those for you. So get in touch with me. I'll have a discovery call. We'll then do a demo, which is an hour and a quarter, no more than that.
Okay, thank you. And the other point that I was interested in is the integration point that you made and the different search companies. My guess is, well, I know that you're happy to look at integrating with other companies, etc., where appropriate. Yeah.
Yeah, we're completely vanilla. We don't mind who we integrate with at all. And one of our and we get referrals from them as well is InfoTrack, who are owned by the same people who own Leap software. Yeah. So we get referrals from them as well. So and Leap is a competitor of ours, obviously. Yeah. So we don't care. No, we'll if you've got somebody you want us to integrate with, integration is a lot easier than it used to be 5-10 years ago.
Right. Okay. Richard, as ever, thank you so much for your time this morning and this afternoon. It's really appreciated, and look forward to dealing with you sort of again shortly in the future. Are you sticking with us, or?
I'll definitely stick with you. Yeah, I'm always interested to hear what is concerning people.
Lovely. So if anyone has any questions for Richard or for Liz or Robert at Stewart Title, use the chat facility. And the other thing, of course, is to put any topics you'd like to discuss in the chat facility as well, and we'll have a look at them. So I had some things that I'd like to talk about today. But again, remember, these are ideas and topics that I have, and you're more than welcome to fire in the chat any topics that you've got. So I'll just go through them. First of all, I'm interested in climate change and conveyancing to explore the potential for liability with regard to climate change issues. Then I want to talk about, I don't know if you've seen it, the new National Risk Assessment for Money Laundering and Terrorist Financing, highlighted in the Law Society of Northern Ireland's website just recently. Then I want to talk about defective premises and this case of Ulster Garden Villages, which is quite an interesting 2024 decision, and to see what the Northern Irish government is doing with regard to the BSA. BSA, of course, not live in Northern Ireland, and I don't think it's likely to be, but I'm aware that the Northern Irish government is wanting to do something with regard to building safety post-Grenfell. Then I'd like to talk a little bit about artificial intelligence and a guy called Professor Richard Susskind from Oxford University. To be honest, I looked at artificial intelligence. I was very interested to hear what Richard had to say and thought, when is artificial intelligence really going to bite in the legal profession? And is it going to bite during my working lifetime? And to be honest, up until about 2 or 3 months ago, I thought it's not going to be that important. It will be a useful tool, but it's not going to change the landscape. Having said that, last week or the week before, I was with a dear friend of mine, a guy called Nigel Clayton, who sits as a part-time judge, and he said that the Judicial Studies Board had been providing training to the judiciary about artificial intelligence, not the current version of artificial intelligence, but what's on the horizon. And that's artificial general intelligence. And there's a guy called Professor Richard Susskind, who's the guy to go to with regard to artificial intelligence in the legal sector. And there's some interesting views with regard to that I want to share with you. Some of it touches on the point that Richard was making a little earlier about the fact that if we're freeing up time with regard to procedure, what does that mean? And I think what it means is the sort of human touch becomes more and more important. But I'm not going to steal my own thunder. I'm going to talk about that a little later. I also want to talk about how we report on title, and I'd also like to spend a little bit of time and perhaps having a chat with John, Liz and Robert about defective title insurance issues. So first issue, they got climate change. The current position in the Law Society of England and Wales is that a conveyancer or solicitor conducting a conveyancing transaction should advise clients that it is possible to obtain a report that looks at risk issues associated with climate change. That guidance is not you're negligent if you fail to obtain a climate change report. That is it's guidance for the profession, but there is sort of legal opinion sitting behind it that says potentially you could be negligent if you fail to advise the client about the availability of a climate change report in the conveyancing process. Where the Law Society of England and Wales, I think, have got it wrong is that they sort of muddied the waters and said that solicitors or conveyancers should be advising clients about general issues relating to risk and climate change. I think that's very dangerous. Unless you're confident in having the appropriate expertise to give clients advice relating to climate change, I think your position should be we can obtain a climate change report for you. If we do obtain such a report and there are questions or issues relating to risk when that report is received, we can't advise on it. All we can do is recommend that you contact the report provider to seek additional advice and guidance. So my first question this afternoon is, of the firms that are attending today, anyone actually recommending a climate change report for your client? So Donna, I know you're in attendance. James, I think we've got 2 James. Kathy, anyone else advising clients that a climate change report could be obtained? And where you are obtaining a climate change report, are you scoping your retainer and reporting that you're not actually going to be giving advice on climate change issues? So I'm just going to leave that open and see what people have to say. And I'm going to move on to my next topic, which is the National Risk Assessment of Money Laundering and Terrorist Financing 2025, published by the National Crime Agency. And I've got it on another screen at the moment, and I've been looking at it at length today. And there are a number of important things that I want to share with you. Firstly, conveyancing remains a major issue, described in the latest guidance as an inherently high-risk activity and a high risk that conveyancing services are abused for money laundering purposes. The purchase of property in the UK is attractive to criminals who seek to launder large sums of illicit funds in single transactions. Well, nothing new there, is there really? However, 1 or 2 things that I think are really interesting, and I want you to have a look at your money laundering policies, and I want you to highlight this and make sure that Fiona, as a member of staff, when they're assessing risk, are assessing this particular issue. I think it's 5.203 of the latest guidance. Conveyancers who deal with prime or super prime property purchasers are more likely to be exposed to higher risk persons, such as political entities, overseas buyers, where it may be more difficult to assess sources of wealth. Number of things from that. I think you take from that, if you haven't already, that prime or high value properties are additional risks as far as money laundering is concerned, and therefore enhanced due diligence will be necessary. The second thing that I'll take from that is that it will be necessary when dealing with certain types of client, overseas entities, politically exposed persons, etc., that again, they are at the high end of risk level, and further enhanced due diligence is performed. Someone was asking me about this on Friday. Assessment of wealth. What does that mean? It means that you've got to look at the circumstances of the client and say to yourself, does what I know about this client sit comfortably with what I'm being instructed to do? Let me give you one or two examples. An unemployed client who you know has been unemployed for a number of years is buying a property somewhere out in the sticks and is paying £2.5 million for it. Okay, how has that amount of wealth been obtained to facilitate the purchase? Someone that's been in receipt of benefits and has conceded that to you is highly unlikely to have the resources saved for that purchase. There could be perfectly valid reasons for the purchase. 1, an inheritance. 2, a lottery win. 3, some form of gambling success. It could be anything. But the two pictures of the client don't tally. Okay. Next thing that you could have with regard to assessing sources of wealth, again, is the wealth sort of fairly immediate or recent, or is it sort of family money? Again, talking to the client, getting background information is going to assist. So all conveyancers and solicitors are very keen to identify sources of funds. I think we've got to be really careful with sources of wealth. And the giveaway or key point that I want to make this afternoon is you've got to record your decision-making process. So let's assume we've got a prime or super prime property purchase, and we've got a high-risk client who we're willing to act for. We need to do a risk assessment. In that risk assessment, we're identifying the issues within the transaction that mean that this transaction is higher risk and why this client is higher risk. We've then got to confirm that we're going to perform enhanced due diligence, and we've got to explain what that enhanced due diligence involves. A few important points that flow from that. You cannot simply do this task when you're onboarding the client and then say, right, task performed, box ticked, I don't have to worry about it anymore. As the transaction progresses, we've got to be alive to other issues that would be additional risk indicators. Those additional risk indicators could be relatively minor. They could, combined with our initial risk assessment, mean that they are major issues, or you could have a cumulative effect of a number of minor issues as the transaction progresses that means there's a greater risk with regard to the transaction. The next point that I think is important is that there should be certain points within the transaction where there's a risk review. So, for example, on a purchase, when funds have been called for from the client or where funds have been received before we're exchanging contracts, it might be appropriate to undertake a further review of risk. And the same thing might be appropriate just before we complete as well. So have a look at that guidance. It is relatively digestible. I'm just going to flick through some of the headlines from the guidance. UK continues to be exposed to a high level of money laundering. I've just recently done a webinar on cryptocurrency and did loads of research with regard to that with the National Crime Agency and some of the American law enforcement agencies, and that's pretty scary, to be honest with you. Don't know whether anyone who's attending today would be willing to act on a transaction where a client was buying using cryptocurrency or paying fees with regard to cryptocurrency. The general consensus seems to be, when you talk to firms, no matter what the jurisdiction, we're not prepared to touch it. There are some firms in London that are prepared to act where a client is purchasing with cryptocurrency, but additional measures and checks are appropriate. There are companies now that will verify the platform that's being used in connection with the acquisition of cryptocurrency, will investigate sources of funds where cryptocurrency was purchased, and will produce a report to see where cryptocurrency has increased or enhanced its value, how it has done so. So there are companies out there now that will provide additional due diligence for you with regard to cryptocurrency. But having said all of that, firms are reluctant to get involved. Why? Professional bodies are saying don't. National Crime Agency is saying really, really high risk. Next thing that's mentioned in the guidance, sanctions issues. And again, if I turn to cryptocurrency, where is the platform, the fund, the cryptocurrency fund, where's it based? And if your client has a crypto wallet, who's provided the wallet and where are they based? So looking at some of the work that's been done in the United States, there are cryptocurrency wallets where the entity that's created the wallet is based in North Korea. There are others that are based in places like Venezuela and Russia. So again, there's always a sanctions issue with regard to that, not just the cryptocurrency itself. Next thing, terrorist financing, again, is sort of highlighted in the latest guidance, so that hasn't gone away either. Important, have a look at it. I would certainly say that if you have a policy with regard to money laundering, it is revised and reference is made to this concept of sort of high value properties that I mentioned a little earlier. I think that's the key takeaway that certainly needs addressing as quickly as possible. The other thing that guidance assesses is some of the fines and some of the activity involving professional bodies and non-compliance with money laundering legislation. And again, some scary stuff with regard to that. I think that's just put in there to terrify the living daylights out of all professional persons and entities on the basis that non-compliance can lead to sort of serious sanction. Anyone got any questions or queries on that? Has anyone looked at it? Anyone seen it? I think it came out last week. As I say, it's not that frightening. There's nothing there that says, wow, you know, this requires radical revisiting of policies and procedures. I think it requires tweaking and nothing more than that. Okay, the next thing that I wanted to talk about on my list was this case of Ulster Garden Villages and Farrens 2024 decision. And the reason I was looking at it, I was looking at the Building Safety Act in England and Wales and its application in Scotland and application in Northern Ireland. And of course, I've become aware that Section 134, 135 Building Safety Act, which I'm really interested in, has no application in Northern Ireland. And one of the things I was interested in is where there are defective works with regard to buildings. And I think this case involved a mixed-use development in the centre of Belfast, which was a 9-storey residential development known as Victoria Square. And I think there was problems with regard to reinforced concrete structural columns failing. Hi, Robert. Are you wanting to say something, or just put your microphone on? Or I'm assuming you didn't want to say anything. That's fine. And again, those failure of the columns meant the building had to be evacuated. That took place in 2019. And then remedial works were carried out in order to prevent the collapse. It's been alleged that some remedial works were carried out, but the plaintiffs have been unable to state by whom and when. And the original contractors said they didn't carry out the remedial works. You then had the, in essence, the owner of apartments in the building, Ulster Garden Villages, which acquired 54 out of the 91 apartments, bringing proceedings. Other owners of various individual flats and apartments also joined in those proceedings. Defendants were the contractor and the professional team, architect, engineer, etc. Again, this was a claim for breach of statutory duty and negligence because there wasn't any contractual relationship. The law here, of course, is the DPO, and it was Article 3 relating to defective design or workmanship. And there was an application made by the defendants to strike out on a limitation point. And the interesting thing about the court was that although the text of DPO was the same as Section 1.1 of the Defective Premises Act 1972, the limitation point that arises in the Defective Premises Act, courtesy of amendment, courtesy of the Building Safety Act, didn't apply to Northern Ireland. Cutting to the chase, the court held that there wasn't a direct cause of action under the DPO which survived the limitation period. The court didn't accept that the 6-year limitation period was reset as a result of remedial works. So this was a case where, although the BSA didn't apply and the Defective Premises Act, as amended in England and Wales, didn't apply, the court wasn't prepared to extend the limitation period in this particular case. The interesting thing from that is the Minister for Department of Communities in Northern Ireland said that there was a desire to bring the law in Northern Ireland into line with England and Wales to amend the limitation periods. So again, it's just keep an eye out for that. As far as the Building Safety Act is concerned, in England and Wales, if you're interested, it has been a bit of a nightmare. It's a bad piece of legislation that's got the world and his dog confused as to what people can and can't do. And some of the ramifications of non-compliance are absolutely horrific. Over the weekend, I've been doing some work for some dentists who purchased or about to purchase a surgery in a building in Bristol. No one, solicitors, architects, contractors, client, thought the Building Safety Act had anything to do with this building. The dental surgery company entered into a lease, were given a rent-free period to carry out works starting to trade, and they found, when drawings have been done and specifications prepared, that this is a higher risk building for the purpose of the Building Safety Act, and therefore the Building Safety Act regulator has to approve the works that are being done. So turmoil has been created as a consequence. Anyway, enough of that. The next topic I have is artificial intelligence, and I repeat, this guy's name is someone to look out for. A guy called Professor Richard Susskind, and he is from Oxford University, and he's the most renowned author on the future of legal services and a leading expert on the impact of AI on society. As I say, the Judicial Studies Board have asked him to train the judiciary with regard to the impact of artificial intelligence on the court process. In essence, there are a number of things that he's saying that I think are really important and of general significance. The first is, if you were like me and you're thinking the full impact of artificial intelligence is 5 to 10 years away, you've got it wrong. It is likely, or artificial general intelligence is likely to have a major part in all aspects of the delivery of professional services in the next 2 years or so. The next thing is, according to Richard Susskind, you could see courts without judges, court hearings without the need to appear at court, artificial intelligence, artificial general intelligence, performing the same function as a judge. He distinguishes current artificial intelligence as a sort of a librarian. And what he says is artificial general intelligence is that instead of simply trawling the internet for data and information, artificial intelligence, artificial general intelligence, thinks for itself and will look at facts, will look at plans, will look at the law and say, right, that's what the position is. Now, it's not as scary as all of that. Really touching on the point that Richard was making a little earlier about the use of InTouch. What you have is an opportunity. If we're going to have artificial intelligence performing all of these functions, I think lawyers have two functions. One, medium to short term, and two, long term. Medium to short term, I think our role becomes holding the client's hand to say, look, you can use artificial intelligence, it's safe, it works, and if it doesn't, I'm here to cross-check or assess risk, just as I've always done. And I'll translate what artificial intelligence is saying so that you can understand in sort of layman's terms the net effect. So that's the sort of short-term position. I describe it as sort of the hand-holding between artificial intelligence librarian services and the client. Short to medium term. Long term, I think the role of any professional changes. And I think artificial intelligence, in essence, becomes the solicitor or conveyancer. When you look at that and the potential consequences of that, I've latched on to something that Richard Susskind was saying in a lecture, which I think is really interesting. What he was saying is artificial intelligence can today create a rock group, a folk group, whatever you want, and can write music and can play music. Okay, and gives an example of a band that is doing exactly that at the moment. Okay, and the music is good and the music is worth listening to, etc., etc. However, what he says is, would you want to go and see that band? Well, A, you couldn't because it doesn't exist, but B, if you did, you wouldn't be impressed with it because there's no human involvement. Part of the beauty of music, according to Richard, and I've got no reason to argue against him, is this, that you go and see and marvel at someone playing a guitar or playing drums or singing or doing whatever. The fact that a human being is able to do it, you marvel at, and you don't have the same marvel or wonder when it's machine generated. So that's really an extension of the point that I made. You know, you still want a personal touch with the lawyer who's sort of supervising the file, supervising the transaction, supervising the case. So I think the conclusion that Richard Susskind seems to be saying, and he knows far more than me or indeed anyone else looking at it, that it's not as terrifying as you first think. Early stage, medium-term stage were required. Thereafter, our role alters quite radically, but there still is a role for us. Currently, you know, you've got to check what artificial intelligence is generating. That's so current AI. Artificial general intelligence is a bit more sophisticated, and the need to check is reduced. Note, reduced, not extinguished. Next point I want to talk about is reporting on title, and I was talking to the major professional indemnity insurance broker last week about negligence in conveyancing transactions, and once again they were repeating this important point that firms need to make sure that their retainer or engagement letter and their report on title are consistent with one another. You should not be saying to clients in a retainer that you're doing something or not doing something, and then the opposite applies when the report on title is produced. So the obvious and basic example, retainer says, I won't be inspecting the property that you're purchasing, and then during the life of the transaction, for whatever reason, you do inspect it and you do report what your inspection reveals. Insurers are terrified about that. What they say is, always make sure that anything you've said you're going to do in the retainer, you cover off in your report on title. If you are, during the due diligence process in connection with the purchase, going to do something that you said you weren't doing in the retainer, it is necessary to expand the retainer and make sure the client is aware of what that expansion involves and the limitations to it. So in other words, you've said in the retainer you're not doing something. During the transaction, you decide it's necessary to do something. You expand the retainer for that purpose, but then explain that that expansion is limited. You also tell the client where appropriate that you're going to be charging extra for the additional work that you're doing, and then you deal with this in the report on title. In the report on title, we should be highlighting or indicating risk. We should be highlighting or indicating issues that remain outstanding. or issues where the client has said they're prepared to take a view, or issues where the client is relying on someone other than us to assess or determine the extent of the risk. I haven't seen a report on title precedent for Northern Ireland. I've seen a few for Scotland. I don't know if there is such a document. Edith, anybody else? Or do you just create your own form of report on title? I'll see for next time. I'll try and dig out and see if there's anyone, if the Law Society, for example, has a precedent that can be used. Certainly, there are lots of precedents in England and Wales. I know there are precedents in Scotland. I'm assuming there's got to be something in Northern Ireland. I'd be very interested in seeing it, and I may see if I can dig something out for you for next time. The last thing on my list today, you create your own, Edith, do you? Right, okay, yeah. And do you, yeah, Law Society one for lenders, yeah, of course. Edith, can I ask you a question? As far as the report is concerned, is it one large report when you've completed due diligence, or do you drip feed the clients with interim reports? And there's two schools of thought, neither which are right, to be honest with you. I tend to think it's better to drip feed clients, so I'd produce interim reports as the transaction progresses. But I can well understand why some would say, no, it's better to have one report on title that the client reads, considers, and approves before proceeding to an exchange. The reason that I like interim reports is I like the idea of drip feeding a client. Two, I like the idea if there's an issue that I encounter to draw that to the client's attention at the time I discover it. Yeah, because I get that, Edith, right? But providing an update as the matter progresses is fine. If you are going to use an interim or series of interim reports, the final report should have a summary indicating that the other reports have already been provided and indicating to the client important issues. The problem with that is if you produce a summary, then are you sort of highlighting some issues and ignoring others? So there isn't a magic way. The key is, however, it's important to make sure that the client confirms receipt of a report, confirms it's been read, confirms it's been understood, and you ask the client if they have any questions or queries concerning it. So thanks for that, Edith. Thank you very much. Okay, the last topic on my list are issues with regard to defective title insurance. And there's a few things here, and I'm sure Robert, John, and Elizabeth will join in where appropriate. First point, with regard to defective title insurance, I'm of the view that it should always be taken out by the buyer and not the seller. The reason for that is threefold. One, it's the buyer that needs the policy. Two, if I'm acting for a buyer, I want to know that the policy that I'm obtaining is suitable for my client's needs. Three, I think there's an inbuilt risk if the seller issues or obtains a policy that the seller does not disclose to the insurer everything that should be disclosed. If I'm selling a property and I'm moving on, I'm going to look to try and get the cheapest policy I can. Where I know there are problems or issues with regard to the risk, there is a risk I do not disclose what I know to the insurer, thus potentially invalidating the insurance for the buyer. So I think where there's an existing policy or where, for whatever reason, the seller is taking out the policy, I'd want some form of warranties in the contract with regard to the application, with regard to the seller's knowledge, etc., etc. And I'd want to perform due diligence with the insurer. If the buyer takes out the policy, then of course the seller should be making an allowance with regard to cost or paying the premium. So can I ask you, Robert, first of all, hi Robert, are you in agreement with regard to that? I think it should be the buyer that takes out the policy.
Yes, I agree. And I think I'm always very careful when talking to lawyers to say that the information being given is not the lawyers, it's the clients.
Yeah.
All those little boxes we tick to say certain assumptions are true and statements of fact are true. It is actually the client's information. So you do need to know. And also, quite often these days, clients are not buying a house with the intention of keeping it exactly as it is now. They're looking to extend, to put perhaps new buildings in there. So it's a great risk to actually assume it. And you're right, the seller has no way of knowing what's going to happen. And as you say, no real desire to know too much. So certainly I'd agree with that very much.
Yeah, good. And on this issue of sort of ensuring the client is informed, I think there's two things flowing from what Robert and I are just saying. I think obviously when you're taking out the policy, you're going to tell the client about their duties and obligations. I would always remind the buyer client of those duties and obligations when I'm closing my file, because the client sort of in the heat of battle with regard to the transaction may well forget about the policy, may well forget about their duties and obligations. And I think it's useful to remind the client about them when we're closing our file, to say, hey, look, we're out of the picture now, but be alive to the fact that if you become aware of anything relevant to the risk that we've insured or the policy that you've obtained, you need to notify the insurer. I think that's really, really important. So I'd always ensure my last email or letter to the client when I'm about to close the file where I've taken out a defective title insurance policy deals with those issues. The other thing that I think is important with regards to defective title insurance is to explain to the client what the policy does do and what it doesn't do. And again, Robert, you're the expert on this, but I think the important thing is the risk or the issue is still very much alive and kicking and could be a problem and could kick at some point in the future. And as far as the policy is concerned, it may compensate you for diminution in value. It may fund litigation or enable you to defend litigation, but it is subject to the terms of the policy. So, Robert, again, in your experience, do you find that solicitors acting for the buyer are careful to explain to the client what the policy covers and the limitations relating to cover?
I think it varies a lot.
Right.
You and I are both recovering conveyancers, so we have bought these policies or similar policies in the past.
Yeah.
And I know it's very easy to summarise to the client, we've found a problem and we've solved it with title insurance. I'm sure I used that phrase when I was practicing. And of course, you're not, as you say, you're giving a weapon for a future battle. And clients really need to understand that, and also the difference between the market value, the financial value of a property, and the emotional value. Very few of us buy a residential property anyway. Our main home is purely a financial deal. There are a whole host of other emotive things there. Right catchment area for schools, close to in-laws for free baby care, close to the station, that sort of thing. Those would not necessarily be caught by diminution in market value. So I think it is important. I think it can be summarised fairly easily for lawyers, but I do think you need to put that in there so that people are aware, because otherwise they can believe that it's some sort of magic wand which will get rid of all of their problems, which sadly it's not.
Yeah, Robert, can I throw a curveball in there, right? So let's assume that I'm saying, right, the reason I'm buying this property is because it's adjacent to a lovely park, adjacent for schools, near a golf, whatever the reason, right? Could you take out a policy that sort of takes into account the disturbance or disruption of the fact that I can't live there, or those amenities that are reasons why I purchased the property are not likely to be as accessible? So in other words, can I say to you, this is the cover that I want rather than this is the cover you can give me? So could I insure for something, say, more than the market value of the property?
I think it would be very difficult. You can, in commercial cases, obviously include disruption of trade, interruption costs, things like that. But it would be impossible. I'm sure John would think this, that it's impossible to quantify that. So how much pleasure you get from a building, from being next to a park, is not something we can quantify. So it's not something we can easily underwrite.
I think that's right, Robert. I think that's right what you're saying. I don't think, from a residential point of view, that we would
entertain it.
We would entertain that. Like Robert says, how do you quantify that? You know, it's all a matter of opinion, and somebody's loss in that respect would seem greater than others. So I've got to agree with you, Robert. Yes.
Yeah, good. All right. Well, I did say it was a curveball, gentlemen, didn't I? So but it's just interesting. But it just highlights the point about what the cover is. And I think the other thing that we alluded to is this idea about drumming home to the client the risk, the issue, the problem still exists. The policy may well meet the client's needs, may well be satisfactory for you as solicitor or conveyancer with regard to this transaction, but it doesn't follow that comfort, that policy is going to be satisfactory for subsequent owners or lenders, etc. And Robert, that brings me to the last point that I wanted to explore. To what extent is a policy that I take out with you transmissible in connection with a subsequent buyer? And again, John, if you can help on that one as well, that'd be brilliant.
Well, I think policies in general cover successors. You should always check the definition of insured on a policy, because we do have some policies that are lender only, NHBC for example. So there are certain policies that are lender only. There are certain policies that only cover the purchaser's lender and successors. So it's a thing you've got to check. But that's usually seamless insofar as long as you can fall within the definition of insured within the policy, the cover's automatically transferred.
Brilliant. Thank you, John. Thanks for that. Okay, well, finally, John, you can help me with this. We've mentioned defective title, policies in connection, servitude, restrictive covenant, planning and building control. John, what are you sort of encountering in Northern Ireland? What are your sort of top 10 policies?
Well, the first thing is if you're looking for a policy, go online first and see what you can get there. But what we generally find in Northern Ireland is build-over agreements, lack of build-over agreements. Access and services is always one, particularly in rural areas. And we do a lot in other jurisdictions, but we do cover alterations, lack of planning consents, etc. So that's worth bearing in mind. And occasionally for Northern Ireland, we see transfers at undervalue or transfers for no value. And all of these, you can go online and get it a drop of a hat. And if there's any issues, it would then be referred to myself or Liz or Robert or whoever.
That's right. Great. Okay. Lovely. Well, thanks very much for that, John. Okay. Well, no one has put anything in the chat by way of topics. So a few things. One, our next forum, if there are topics, let me know. If there are speakers that you'd like to come along, let me know. I will keep scurrying away trying to find topics, etc. And now I'm going to have a look at this report on title points. But in the meantime, Edith, thank you for your contribution today. That is interesting. Anyone got any sort of burning issues or things that are sort of really hot off the press with regard to problems? I think compliance is the major thing. And I was talking to someone yesterday about this, and they were saying they think that nearly half of the fees that they're incurring are compliance related. So 50% of the fees and the work they're doing is to satisfy compliance rather than driving deals forward. And I think that's absolutely crazy, but that's what we've got, isn't it, at the moment? Good. Okay. Any other topics? Anything else that anyone would like to explain or look at? All that's left for me to do is to say, first of all, a massive thank you to Stewart Title for sponsoring today, to John, to Liz and Mr. Robert Kelly. A massive thank you to In Touch and Richard Pickles. Do talk to Richard. Really nice guy, really good company, really interesting product, very flexible. So always worth having a chat with Richard to see what In Touch can do for you. Do talk to John and the team, to Liz and Robert, about any title indemnity insurance that you require. And as far as topics for next time or any questions or queries for me, email address shown on slide. All I'd like to do is wish you a very good afternoon. Thank you for your time and attendance today. Edith, thank you for your contribution today, and have a lovely day and stay safe. Thanks, everyone. Speak soon. Thank you.